Mr. Dunham?
Is Mr. Craddick available for further parliamentary inquiry?
You'll have to answer the speaker when he comes down.
I'm not advised.
How about Mr. Dutt?
State your inquiry, Mr. Dunham.
The chair stated earlier that
Mr.
the
Dunham.
chair... Yes.
Sorry, we're having a hard time hearing you.
The chair stated earlier that the chair could refuse to recognize a member on a question of privilege of the House under Rule 5, Section 24. Is that correct?
That's correct.
The chair stated that there is no appeal from the chair's decision on recognition. Is that correct?
That's correct.
Can the chair then explain to the House how the chair, as a member of the House in 1971, could vote to appeal the ruling of Speaker Mutcher that Ms. Farenthal's resolution to investigate the actions of Speaker Mutcher during the Sharpstown scandal if the Speaker could not refuse recognition? Because Ms. Farenthal moved a question of privilege, Mr. Mutcher did not recognize her, and it says that Mr. Craddick voted to appeal that recognition decision. So what I'd like to ask you, if you voted that way in 1971, why can't this chamber vote that way today?
Mr. Dunham, I'm not sure at that time. Section 20, Rule 5, Section 24 was in the rules, was it?
I don't know. I do have a copy of the motion here, and it says that Ms. Farenthal moved as a matter of privilege to take up and consider at that time HCR 87. The Speaker did not recognize Ms. Farenthal on the motion stating that the resolution was not privileged under the rules of the House, and the recognition cannot be considered at the time. Mr. Denton appealed the ruling of the chair. It was seconded, and Mr. Craddick voted with the dirty 30.
And you don't even know if that rule is...
Mr. Dunham, you're referring to a motion that I don't know whether Rule 5, Section 24 was even there at that time.
The motion was to investigate the actions of Mr. Mutcher.
Mr. Dunham, I don't know whether this rule is in effect. I'm just looking at the rule book right here.
If there's
the
no
rule
motion-
book says, Mr. Dunham,
Okay.
yeah, okay? It says under Rule 5, Section 24, under recognition, there shall be no appeal from the Speaker's recognition, but the Speaker shall be governed by rules and whatever.
So in matters of privilege, they've always not required recognition, Mr. Speaker.
Excuse me?
Matters of privilege have never required recognition. That's why they're called matters of privilege. They are matters that members can bring up, and the Speaker is required to recognize them. It was the same rule, I'm informed. If there is no motion to vacate the chair under the rules as a resolution declaring the office of Speaker vacant, does that present a question of privilege of the House? A resolution declaring the office of Speaker vacant, is that a question of privilege?
It does present a question of privilege, but there are procedural ways in which you can take care of that matter.
And what would those be?
Well,
It's referred to committee unless there's a suspension.
Under Mason's Section 582, isn't the chair supposed to leave the chair during discussion of any business concerning the chair? And isn't that the same under Hines Precedents, Volume 2, Section 1359? And my question basically is, if there is a resolution or motion made in regard to the status of the chair, is that chair the one that's going to rule on whether or not it's in order?
Your first question, that is true. That's if you're recognized.
And although you participated in appealing the Speaker Mutcher's refusal to recognize Ms. Farenthal, you're saying at this time that this body will not have the ability to appeal your decision in this kind of matter?
Mr. Dunham, I'm just reading the rule book that we all use. I don't know whether the Rule 5, Section 24 was there or not at that point.
Yeah, I'll go get a copy and I'll be back.
That'd be great.
In 1971, it's my understanding it was the same rule, but it was Rule 11, Section 3. The number of the rule, and I think it's in the last page. Let's see. Goodness gracious, I had it here all along. I believe Rule 11, Section 3 of the 72nd Legislature says, "There shall be no appeal from the Speaker's recognition, but he shall be governed by the rules of usage and priority of entertaining motions from the floor." I believe that is the exact same rule we have today.
Just have to look at it, Mr. Dunn. Bring him down front and we'll look at it.
I'll bring it down.
Mr. Speaker,
Ms. Smith, for what purpose?
parliamentary inquiry.
State your inquiry, Mr. Smith.
Mr. Speaker, is it true that in rendering an opinion on Mr. Dunham's question that you overruled your own parliamentarian and assistant parliamentarian's advice to you?
Not to my knowledge, Mr. Smith. I'm not advised.
You don't know?
I don't remember overruling my parliamentarian, Mr. Smith.
So you're telling me that Mrs. Davis and Chris advised you that that ruling was appropriate, and your ruling was consistent with their advice to you?
Mr. Smith, I used the rules in front of me, and I asked the parliamentarian, which is an advisor to the Speaker. And to the members
she
of the
told
House.
you that your ruling was correct and she agreed with it?
I looked over and asked her, and I don't know that she agreed or didn't agree, Mr. Smith.
So you're saying, did you or did you not, Mr. Speaker, ignore the advice of Denise Davis in rendering that opinion?
It's a privileged conversation between the two of us, she said. In the presence of the House.
Mr. Speaker,
Mr. Dunham, for what purpose?
parliament inquiry.
State your inquiry, Mr. Dunham.
Has the chair had the opportunity to yet review and compare Rule 11, Section 3 from the 72nd Legislature to our current Rule 5, Section 24 that you cited earlier?
Not yet, Mr. Dunham.
Will you advise us when you've done so?
Sure, she's going to look at it.
Could we put, I would ask to reduce to writing our previous, the second line of inquiry, and your response into the journal.
Members, you've heard the motion. Is there objection?
Could also ask that Mr. Smith's remarks and questions and your answers be reduced to writing.
Oh, certainly. Is there objection, Chair?
Mr. Speaker,
Fitz, what?
parliamentary inquiry.
Parliamentary inquiry.
Who employs the parliamentarian?
The Speaker does, but...
Is she an officer of the House?
I was going to say he or she is a House officer.
She would be an officer of the House.
That's correct.
And where does the privilege come in with an officer of the House, with the Speaker?
It's special counsel because there's attorney-client privilege
She is
as well.
a special counsel for the House, is that correct?
We're her clients. You're a client.
She is to the House, but to each individual member also.
So you're exercising a privilege with your attorney on this matter, is that correct?
Just a minute, Mr. Fitz. Just a moment, Mr. Fitz. Members, we're going to stand at ease till 8 o'clock. House to come to order. Just a minute, Mr. Guerin. I'm going to make a comment. Members, First of all, I'd like to introduce to you the new parliamentarian, Mr. Keel, and the deputy parliamentarian. Be out here in a minute, Mr. Wilson. And we've got 1 hour left in which to complete. There are 11 bills that are eligible between now and midnight. And those are the only ones we're going to try to take up. It's up to you as members. We've got 11 bills that are eligible. Several of those are very important. One of them is the House Bill 15, which is a supplemental appropriations bill. And we're going to try and lay those out one at a time and try to take care of the state's business and get those done this evening before 12.
Speaker, Parliamentary Inquiry.
Parliamentary Inquiry, Mr. Guerin.
Have Mr. Keel and Mr. Wilson been working on your behalf in your office this past week on any other matters?
They've been working with me on a consulting basis.
On a consulting basis for you, not for the House, is that correct?
That's correct, Mr.
And how have you decided that they should now be our parliamentarians?
Within my discretion as Speaker, I've decided.
It's within my discretion as Speaker to appoint them, and we needed a parliamentarian. I did.
Did we not hire the parliamentarian in the resolution at the front end in January, sir?
Tell him the resolution also gives the Speaker
The resolution also gives the Speaker
authority to designate replacements for its officers.
authority to designate replacements for its officers.
Mr. Speaker, I have a problem with you hiring someone who has been representing you for the last week, lobbying members on your behalf, and I think that it just doesn't look good for you to do that, sir.
I know of no lobbying.
I know of no lobbying going on by these members. Members, Mr. Charlton?
Parliamentary Inquiry.
State your inquiry, Mr. Charlton.
Earlier you had talked,
I'm sorry, Robert.
I'm sorry, can you hear me now?
Yes, sir, I'm sorry.
Okay, great. Earlier you had responded to Mr. Dunham's questions as to a motion to vacate as not a matter of privilege. Is that true?
That's correct.
That is correct.
Mr. Speaker, are you aware of the precedence that's been set out?
Yes, I am.
Yes, sir.
And you're aware of 1871, the 12th legislature?
Yes, we are.
Yes, we are.
And you're aware that they said it was a matter of privilege at that time?
Robert, I'm sorry.
Is that better?
Yeah, I'm sorry, Robert.
That's okay, I understand, we got bad acoustics.
There's an echo. I'm sorry, go ahead.
Is that better?
Yes, sir, thank you.
I moved away, thank you. And under that, it said Mr. Butler offered as a matter of privilege
Mr. Charlton,
the motion to vacate a speakership.
Charlton, do you have?
And you're saying that's not a matter of privilege?
Yes, that is what I'm saying.
That's correct.
And based on what?
Tell him if he would like to put his inquiry in writing, we'll be glad to put my answer in writing. And
Mr. Charlton, if you'd like to put your inquiry in writing, we'll be glad to bring it down front. Bring your inquiry down front, we'll be glad.
I'd like to answer get an answer to the question, Mr. Speaker, because it bothers me that we're sitting here calling it a matter of privilege, that you're saying it's not a matter of privilege, when any time that a body an assembly puts a person in, they can take that person out, and that's a matter of privilege. And it's bothersome to me. Do you have a brief on it that we can look at?
yes, we briefed it.
Yes, sir, we briefed it.
Sir?
Yes, sir, we briefed it.
Well, will you share it with the rest of us? Because I'm sitting here looking at the parliamentary law that we've had over all these years under our rules, and it says that it is a matter of privilege.
Tell him that I'm saying.
We'd be glad to share it with all the members at the appropriate time, Mr. Charlton.
And that will be when, Mr. Speaker?
When a member asks for recognition and is recognized.
When a member asks for recognition and is recognized.
And so you can do that whenever you want to, is that correct? Since you have the power of recognition, is that what you're telling this body?
I would refer you to Rule 5, Section 24.
I'd refer you to Rule 5, Section 24.
Oh, I'm quite familiar with that, Mr. Speaker, but I'm talking about a matter of privilege. Are you familiar with Rule 5, Section 35 and 36, when it talks about matters of privilege?
Yes, I'm familiar. Yes.
Yes, sir.
In matters of privilege, you have to recognize, do you not?
No, sir, the power to recognize is absolute.
And you're saying that a person can be kept in office and kept in the office of Speaker or the office of the Chair, and the body that elected them can never take him out. Is that what you're saying?
No, that's not what I'm saying.
No, sir.
What are you saying then?
That the House rules govern that along with the Texas Constitution.
That the House rules govern that as well as the Texas Constitution, or along with the Texas Constitution.
Well, but under our rules, under Rule 14, if you look at Rule 14, Mr. Speaker, and Rule 1, in Section 1, it says that if the rules are silent, then it's the House of Representatives of the U.S. Congress rules and Mason's Manual of Legislative Procedure. Is that agreeable?
Look at those for matters of procedure and questions of order.
You also look to the...
You also look to the Texas Constitution.
The Texas Constitution allows it up to 2 years. It doesn't, a speaker is elected by the body. And if the body can put a person in, are you saying that you can't take him out because of the Constitution? Is that what you're saying?
Mr. Charlton, we're having a hard time.
Oh, I'm sorry. Is that better? I'll
sir.
back
I
away.
think as you lean in, we're having a hard time.
Yeah, I'm going to stay away. I'll try and stay back.
Okay.
So if I understand right, what you're saying then, under the Texas Constitution, that if a body elects a speaker, that body can't take him out of the chair and unelect him?
That's not correct.
Well, then what is a parliamentary inquiry, Mr. Speaker? What is the proper procedure to remove a speaker, a sitting speaker?
The speaker or any other member
The speaker or any other member
can be expelled
can be expelled.
for an offense.
So you're trying to make it a matter of
If you let me
impeachment?
finish, if you let me finish,
Can be expelled for an offense
can be expelled for an offense
upon a two-thirds vote
upon a two-thirds vote
of this body.
of this body.
Now, any member of...
Mr. Speaker,
Mr. Charlton, just a second.
Okay.
Okay.
Any member of this House
Any member of this House
is automatically removed from office
is automatically removed from office
for conviction of bribery.
for conviction of bribery.
So, Mr. Speaker, I want to make sure...
Now finish, Mr. Charlton.
I'm sorry.
The Texas Constitution
The Texas Constitution
furthermore has specific provisions
provisions
dealing with the House
dealing with the House
and its ability to judge the qualifications for office
and its ability to judge the qualifications for office
and election contests.
and election contests.
The exclusive remedies
The exclusive remedies
for removing a state office holder
for removing a state office holder
are contained within the Texas Constitution.
are contained within the Texas Constitution.
Any mode outside of the authorized provisions
Any mode outside the authorized provisions
must be enacted by law
must be enacted by law
and cannot be enacted by one House
and cannot be enacted by one House
by rule or resolution.
by rule or resolution.
Is that all, Mr. Speaker, at this time?
Yes, sir.
All right, then my next question is, are you saying that you have to impeach a speaker by two-thirds vote instead of a simple majority on a motion to vacate? Is that what you're saying?
No, sir.
No, sir.
We would refer you
We would refer you to
to the Texas Constitution
the Texas Constitution
and the exclusive modes for removing a state officer
and the exclusive modes for dismissing a state office holder
that are contained within the Texas Constitution.
that are contained within the Texas Constitution.
And Mr. Parliamentary Inquiry, will you make that brief available to the members today?
Mr. Charlton, I'm sorry, go ahead.
Parliamentary Inquiry, Mr. Speaker, will you make that brief available to the membership today?
Tell him if we have the time.
If we have the time, we'd like to go on. I think most members, Mr. Charlton, would like to go on and finish the items eligible, which I believe we stated earlier were 11.
Mr. Speaker, Parliamentary Inquiry.
State your inquiry, Mr.
Did we recess for over 2 hours without a motion to recess or a vote on that when you walked off the floor?
We didn't have any items eligible at that time.
Mr. Speaker, we could have had these conversations at that time, could we? And he had one that was eligible at that time. Did we not? Was there a motion to recess, Mr. Speaker?
No, sir.
And you just recessed without a motion. Is that correct, sir? And walked off the floor of the House.
If there is objection
Is that correct,
That's the
sir?
speaker's prerogative to do that unless there's objection, Mr. Garrett.
There was objection, Mr. Speaker. There was objection all over the floor of the House, and I know that you don't have a hearing problem that's that bad.
Yes, sir.
Mr. Speaker, did we also adjourn at 7:50, or excuse me, stand at ease at 7:50 to come back at 8 o'clock?
I think we didn't adjourn, Mr. Garrett.
No, we stood at ease at 7:50, and you said we'd come back at 8 o'clock. Is that not correct?
Yes, sir.
And we came back when, sir?
I'm not sure.
About 8:40? All the members of the House were here waiting on you, as I recall.
Yes, sir.
My other question, what happened to our other parliamentarians, Mr. Speaker?
The other parliamentarians, at their request, have been reassigned to another place in the House.
Thank you, Mr. Speaker.
Thank you.
Mr. Speaker,
Mr. Smith?
parliamentary
What
inquiry.
purpose?
Uh,
For what purpose, Mr. Smith?
May I be recognized for a parliamentary inquiry?
I decline to recognize you this time because Fred Brown is going to have the floor to take
No.
HB.
Just state your parliamentary inquiry.
Mr. Speaker, it's my understanding that Mrs. Davis wrote a letter of resignation. Is that correct?
Mr. Smith, we cannot discuss personnel matters.
Would it be within the rules to provide that letter of resignation be placed in the House Journal?
That would be up to the parliamentarian and deputy parliamentarian.
That'd be up to the parliamentarian and the deputy parliamentarian. Who submitted those letters? I think we'd have to ask them.
Okay, to the parliamentarian who submitted the letter?
Correct.
That's correct, Mr. Smith.
It's my understanding that you did not even seek her advice in ruling on this particular question. Is that correct?
Mr. Smith, that's not a proper parliamentary inquiry.
That's not a proper parliamentary inquiry, Mr. Smith.
Well, then let me can I ask a question of you?
State your inquiry, Mr.
A parliamentary inquiry?
State your inquiry, Mr. Smith.
Will you, is that true or not that you did not even seek her advice on that particular ruling?
It's not a proper parliamentary inquiry, Mr.
Will you answer a question?
No, sir, I will not. I need to move on to House.
No, sir, we're going to move on to the calendar.
Parliamentary inquiry.
State your inquiry, Mr. Smith.
It's my understanding that your position is that because the Speaker is a constitutional officer, that the Constitution provides the manner by which that officer may be removed. Is that correct?
That's correct. I think Mr. Talton asked that just a few moments ago.
You are aware of the fact that this is not the first time a sitting Speaker, that there has been an attempt to remove a sitting Speaker from our state's legislature, are you?
That is correct.
That is correct, Mr. Smith.
And are you aware of the fact that in the only precedent of this particular activity in 1871, that the wording in the Constitution was effectively identical to the wording in the Constitution today, and the procedure that was followed in removing the Speaker is the procedure that we believe should be followed today?
Correct, Mr. Smith.
It's not the procedure that you are recommending and advocating today to this body. Is that correct?
Your last statement was incorrect.
Your last statement was incorrect, Mr. Smith.
So is it your position that the Speaker at that time was removed pursuant to the impeachment articles in our state's Constitution?
No, I did not say that.
No, I didn't say that.
Is it your position that the manner in which the Speaker should be removed, if he is to be removed today, is the same procedure that applied in 1871?
There is additional constitutional provisions that did not exist in 1871.
There are additional constitutional provisions that did not exist in 1871.
Can you tell us what those constitutional provisions are and the extent to which they dictate a different result and when they were passed?
Among others,
Article 15, Section 7.
Article
15.
Section 7,
And other provisions.
and other provisions.
Furthermore,
Furthermore,
the legislature of the House and Senate
the legislature of the House and Senate
have never enacted by law
have never enacted by law
since 1871
since 1871
any statute that would provide for the procedure to do what you are suggesting.
Any statute that would
Provide for the
provide for the procedure that you're asking,
suggesting.
of what you're suggesting.
The legislature cannot by rule
The legislature cannot by rule
overrule provisions of the Texas Constitution.
overrule provisions of the Texas Constitution.
Go on the council.
Is it your position that the speaker may not be removed from office by the members who elect him?
There are provisions to remove a speaker by the members.
There are provisions to remove the speaker by members.
And I've stated what those are.
And I've stated what those are.
Okay, and can you tell me again what that is?
No, sir, we don't have, you can.
Mr. Smith, we said we'd put this in the journal and submit it. I think that some members would like to go on with the state's business, and I'd be glad to visit with you after that, but I think it's real important in the next 45 minutes we take up several bills.
Mr. Speaker, we've had 5 hours, excuse me. Are you finished?
Yes, sir.
We've had 5 hours
For what purpose, Mr. Smith?
to respond to your comments. May I? Parliamentary inquiry.
Certainly.
State your inquiry.
State your inquiry, Mr. Smith.
Where were you for the last 5 hours when this business could have been taken up?
That is not a proper parliamentary.
That's not a proper parliamentary inquiry, I don't think, Mr. Smith.
You refer to parliamentary inquiry.
State your inquiry.
State your inquiry, Mr.
You referred to Article 15, Section 7 regarding the removal of officers. Is that correct? In support of your position?
I'm sorry, Mr. Smith.
You referred, I believe, to Article 15, Section 7 in support of your position regarding the removal of officers. Is that correct?
Among other provisions.
Section 2, is it your position that impeaching the Speaker is one of the ways by which we can remove him from office under certain circumstances?
Any member can be removed
Any member can be removed, including the Speaker,
upon a two-thirds vote.
upon a two-thirds vote in the House
For offenses
that
that the House determines
in
in a procedure to remove that member
a procedure to remove that member
or speaker.
or Speaker.
Can you help me understand?
We've already,
We've already answered this question
we've already answered this
in
question
response to Representative Paulson.
in response to Representative Paulson.
At this time, the chair goes.
Mr. Speaker,
Yes, sir.
would it be possible for Speaker Craddick to take the microphone? I've got a question I think that only he might be able to answer. Parliamentary inquiry, Mr. Speaker.
State your inquiry, Mr. Garrett.
Mr. Speaker, and I think I already know the answer to this because I value the way that you're fair with all races and religions, but are you aware that in a public meeting, in a public forum, that the assistant parliamentarian used racial slurs against a member of this House?
That's not a proper parliamentary inquiry, Mr. Garrett.
Mr. Speaker, with that knowledge,
What purpose?
parliamentary inquiry,
State your inquiry, Mr. Garrett.
with knowledge of that, I find it very difficult to think that we could continue to have him serve as our attorney, not just yours, but our attorney, and that if he wouldn't do the honorable thing and step down, I would request that you ask for his resignation and limit his access to the House to those areas that are only public while the House is in session. I know that you are very sensitive to racial issues, as I hope most all of the members of the House, but I just find that an action that he's grinning about it now, so I guess he still thinks it's funny. But it's a horrible thing that took place, and I would hope that he would do the honorable thing and resign. Thank you, Mr. Speaker.
Mr. Speaker,
Yes, sir. For
could
what
I
purpose?
ask Mr. Craddick another question? If it's on imposition?
For what what purpose, Mr. Dunn?
What purpose, Mr.?
Parliamentary inquiry, Mr. Speaker.
State your inquiry, Mr.
Can you, and maybe someone's explained this, but can you explain to me the presence of DPS officers in the back hall, additional DPS personnel, in the doorway to the house? Is there some security danger that we are not being made aware of? Who are they here to protect? Why do we have DPS here in positions and in numbers that I have not seen in my 6 terms?
Mr. Dunham, I received your letter regarding the list of distributed,
Mr. Speaker, that letter was not from me. I think my office handed it off, but that letter was from Mr. Martinez Fisher, Mr. Herrero, Mr. Martinez, and someone else. That's not what I'm asking about. I'm talking about the presence, the physical presence of DPS personnel, two right outside this door, one outside of each one of these doors, upstairs where we've never had them before. Is there a security risk that we need to know about? Do we have threats that have been made to the chamber or any members of the chamber? Is there a reason for the heightened security around the chamber that warrants these gentlemen and ladies being present in their location?
Mr. Dunham,
As I tried to tell you a moment,
as I tried to tell you a moment ago,
in response to the letter you sent on,
in the response to the letter that you sent or we got from your office,
the Speaker's office did not have any interaction with DPS.
the Speaker's office did not have interaction with the DPS on this.
We do know of one member
We do know of one member
who has had threats on her life,
who has had threats on her life.
and that may be related to that, I do not know.
That may be related to it, but I don't know.
You should direct those questions to the Chair of House Administration.
You should direct your questions to the Chair of House Administration, Mr. Goolsbee.
And just so that members, you brought up a letter. The letter had to do with instructions that DPS had received that certain members of this body would not be shown on video and the microphones would be turned off on those members as a matter of standard practice. And I do know my office hand-delivered the letter, but that was at the request of Mr. Martinez Fisher and the other members who signed the letter. I didn't sign the letter. So you don't know why we have extra DPS in the front hall and the back hall.
No such list has been distributed, nor anything like it has ever been created or verbally communicated to the Sergeant at Arms or the DPS. So you need to talk to Mr. Goolsbee, Mr.
So Mr. Goolsbee is responsible for the additional DPS?
He's the chairman of House Administration. If you have any questions about it,
Well, I mean, he had nothing to do with the hiring of the parliamentarians, and he's supposed to have something to do with that, too. Are you telling the body that you have
You're
no
not
idea?
correct on that, Mr.
You don't have any idea why we have additional troopers in the building?
No, I'm not advised.
Mr. Speaker, I have another parliamentary inquiry.
Okay, your inquiry.
Have you been provided with a copy of, it's my understanding that your position in regard to your office is that you are a state official or state officer? Is that correct?
That's correct.
Are you aware of the Texarkana court opinion that we've delivered to the parliamentarian's office that states that specifically that the Speaker of the House is not a state official or state officer?
We are aware of it, and that's an incorrect statement.
So it's an incorrect statement that the case says that?
That's
The
correct.
case was quoting a Colorado
That
court.
case was quoting a Colorado court.
It's a Texarkana Court of Appeals opinion, you're aware of that? And so you choose to...
We are aware of that, and we've entered in the journal our answer.
We've already addressed it.
Mr. Speaker, let me ask one last thing.
For what purpose?
I have one more parliamentary inquiry. Regardless, assuming that there's 149 members in this chamber that would vote to vacate the Speaker's position, are you still not going to recognize anyone for any such type motion? Regardless of how many members want to vote on it.
We've already answered that.
We've already answered that question several times.
Well, I don't think that question's been asked.
We've already answered it, Mr.
You're not going to recognize it?
That is correct.
That motion will not be
Let me ask then, is there any procedural mechanism that this chamber has? If a majority of members want to vacate the chair, is there any procedural mechanism that you will recognize to give us the opportunity to just have a vote and let the will of the majority be determined? Is there any procedural mechanism that you will recognize?
We're going to follow the rules of the House.
And I'm asking, under the rules of the House, and that's why this is a parliamentary inquiry, under the rules of the House and the Texas Constitution, is there any procedural mechanism that you will recognize that will afford this body the opportunity to determine whether or not the chair should be vacated?
There is no procedural method
Under the rules of the House.
under the rules of the House.
That you will recognize?
That is correct.
I mean, we could file, for example, we could file a privilege resolution. I'm just asking, is there any mechanism, procedural mechanism available that you will recognize that will allow this body to vote one way or the other whether to vacate the chair?
None exists in the rules.
And so, in regard to, you are aware of the Texarkana case of Diffie versus Cowan that says that the Speaker of the Legislative Assembly is not a state officer. You just believe that that is incorrect.
You need to read our journal entry. We've answered that.
Well, were you aware of this case when you made your entry in the journal?
All cases.
Yes, sir. Yes, sir, all cases.
Mr. Speaker,
Mr. Marino, for a
parliamentary inquiry, Mr. Speaker.
state your inquiry, Mr. Marino.
Two,
Mr. Speaker,
Mr. Strong, for what purpose?
I'd like to move, if I may be recognized
For what
to do
purpose,
so,
Mr. Strong? But for
I'd
what
like to
purpose?
move that the remarks between you and Mr. Dunham, between you and Mr. Guerin, and between you and Mr. Moreno be reduced to writing and placed in the journal.
Members have heard the motion. Is there objection? Chair retains one.
Mr. Speaker, parliamentary inquiry.
State your inquiry, Mr. Strong.
I have seen in the journal a decision that is not to be called a ruling that justifies your position that a motion to vacate is not a motion that can be made on this floor. Has there been any substantiation of the Speaker's position that the power of recognition is absolute?
I refer you to Rule 5, Section 24 of the House Rules.
Has there been any precedent cited in arguing that Rule 5, Section 24 of the House Rules contravenes all the other rules of the House that compel the Speaker's recognition? For example, throughout Rule 6, establishing the order of business and the calendar.
Yes.
What is that precedent?
U.S. Congressional President?
U.S. Congressional Precedent.
I'm sorry?
U.S. Congressional Precedent.
And the
What is
explanatory,
that precedent?
and the explanatory notes
And the explanatory notes
of the House rules,
of the House Rules,
including House Rule 1, Section 9B,
including House Rule 1, Section
9B,
9B,
as well as Rule 5,
as well as Rule 5,
Section 24.
Section 24.
I would refer you to the congressional precedent on those rules,
I'd refer you to the congressional precedent on those rules,
as well as the explicit rules themselves,
as well as the explicit rules themselves,
which are specific and unambiguous.
So, Mr. Speaker, is the Speaker's
For what purpose?
parliamentary inquiry,
State your inquiry.
if the power of recognition is absolute, can the Speaker ignore a rule, for example, that compels closure of debate upon request for the previous question, motion seconded by 25 members, and the vote of the House says we must vote? Is the Speaker's power of recognition so absolute that he can recognize additional speakers in contravention of that rule?
All motions require recognition by the speaker.
Can the speaker recognize a motion that is out of order?
I'm sorry, I couldn't hear you, Mr. Strong.
Can the speaker recognize a motion that is out of order under the rules?
Not without objection.
Does that mean that the objection overrules the speaker's recognition?
No, there is no overruling the speaker's recognition.
Is the speaker required to recognize a member for a parliamentary inquiry?
No, sir.
Is the speaker required to recognize a member on a question of privilege under Rule 5, Section 36?
No.
Is the speaker required to recognize a member to explain his bill under the rules of the calendar?
No, sir.
Can the speaker recognize a member who is not the author of a bill to lay out that member's bill in contravention of the author's will?
It just depends.
How is that if the speaker's recognition power is absolute?
I've already explained to you, Mr. Strong.
We would direct you to Rule 5, Section 24.
We would direct you to Rule 5, Section 4.
24.
24.
And
Rule 5, Section...
And
Rule 1, Section 9.
And Rule 1, Section 9.
And the explanatory notes.
And the explanatory notes.
Do you have a different parliament, do you have any additional parliamentary inquiries?
Do you have any other parliamentary inquiries, Mr.
Yes,
Strong?
sir. I wasn't sure you were finished. Rule 5, Section 6 says that when a quorum is not present, only a motion to adjourn or a motion for a call of the House is in order. Is the Speaker's power of recognition so absolute that the Speaker, in absence of a quorum, may recognize a member for any other purpose in the absence of a quorum?
Rule 5, Section 24
Specifically states whether or not a request for recognition will be granted. And the Speaker decides it on each motion
And the Speaker decides on each motion that is made.
The Speaker would be guided
The Speaker will be guided,
in terms of order of priority,
or
in terms of order,
Mr. Speaker,
in terms of order of priority,
by the modes, by the order of priority of the bills in the House per the rules.
by the order of priority
Set out in the rules.
set out in the rules.
We can't hear the answer.
Mr. Speaker, I can't understand the answer. It's a little bit disjointed. Could you please state that again?
We've stated this over.
Mr. Strong, we've stated over and over again,
That Rule 5, Section 24 gives you plenary authority of recognition, but you've said that it doesn't, for example, necessarily give you the power to recognize a member other than the bill's author to explain the author's bill. Is that correct?
not just that rule, also
Rule 1.
Rule 1, Section 9.
I've read Rule 1, Section 9. I've also read the congressional precedent you've cited on page 6 of the 80th Legislature's rules that says, while circumscribed by the rules and practice of the House, the exercise of the power of recognition is not subject to a point of order. Is the circumscription of the rules and practice of the House referring to the rules that govern the compulsion of the chair to recognize members when they are in order?
Mr. Strong, you need to read the rules,
You need to read the journal entry,
the journal entry.
and because none of the matters you were speaking of are proper parliamentary inquiries, because we've already gone over,
Mr. Speaker, I've
Since none of the
matters you are going
matters you are going over
are proper,
are proper
they've already been addressed.
since they've already been addressed.
You need to step aside.
You need to step aside and
Enter a journal entry.
and then enter a journal entry
If you have a disagreement.
if you have a disagreement.
I have one more parliamentary inquiry, Mr. Speaker, with your permission.
State your
Rule 7,
State your inquiry, Mr.
Rule 7, Section 21 allows 25 members of the House to second a motion for the previous question. It then states that the question shall be put by the chair in this manner and prescribes the behavior of the chair when that motion is correctly placed. Is the speaker compelled to recognize such a motion? Or is the powers of the speaker to recognize so absolute that 25 members of this House, following the rules of the House, are ceded to the plenary authority of the speaker to decide against their will?
Your question is answered by Rule 5, Section 24.
Would you please place in the record some analysis of precedent and of the congressional precedent cited during our colloquy?
It's in the record because it's contained in our rules.
Thank you, Mr. Speaker.
Mr. Speaker,
Yes, sir. Well, for what purpose?
the parliamentary inquiry.
State your inquiry.
Yes, sir. In order to be clear that there's no misunderstanding regarding the motion to vacate, I have some parliamentary inquiries. The first one is, there have been no articles of impeachment filed to remove you from office from your duly elected position as representative of the Texas House of Representatives for your district. Is that correct, sir?
That's correct.
Nor have any documents been filed to expel you from the Texas House of Representatives. Is that correct?
That's correct.
Is it the chair's understanding that the chair has been asked to recognize a motion to vacate the chair?
I believe that some members have asked to be recognized for that.
Yes, sir. Is it the chair's understanding that the motion to vacate is not a motion to kick you out of the Texas House of Representatives?
Mr. Leibowitz, if you'll read our journal entry
And the applicable provisions
and the applicable provisions
cited therein.
cited therein,
It answers your inquiry, and we've already.
it answers your inquiry, and we've answered this.
I want to make sure that we're all completely on the same wavelength, Mr. Speaker. And I want to be clear that what is being asked of the chair understands that is what is being asked. And I would kindly request an answer to my question. Yes, I have. I've actually read the journal entry several times, sir, and dissected it, and I'm just asking kindly for an answer to my inquiry.
You have any debate about it?
You may make your own journal entry, Mr. Leibowitz, if you have any debate about what we've already stated in the journal.
I mean, we conclude that it's the chair's understanding that the motion to vacate is not an effort to kick Mr. Craddick out of the Texas House of Representatives.
Mr. Leibowitz, we refer you to the journal entry.
The answer is not there, sir. Is it the chair's understanding that the motion to vacate is not a motion to expel the chair from the House of Representatives?
Mr. Leibowitz, we refer you to the journal entry.
Okay. Well, sir, I'm making the inquiry respectfully because the answer to my inquiry is not in the journal.
I disagree, respectfully disagree with you.
Parliamentary inquiry, Mr. Speaker.
State your inquiry.
Sir, you do understand, do you not, the difference between impeachment and expulsion on the one hand, where someone is being kicked out of office and out of an elected body to which they were elected by the citizens, and on the other hand, vacating a position internally within a body, a position to which the person was elected by the other members of that body. Do you not, sir?
Clear to me.
Mr. Leibowitz, the rules and the Constitution are clear to me.
If they are not clear to you,
If they are not clear to you,
you are welcome to
No,
make
you are welcome to make your own
journal entry.
journal entry.
I just want to make sure we're on the same wavelength, Mr. Speaker. I have one or two more questions. Parliamentary inquiry.
State your inquiry, Mr. Leibowitz.
Does the chair understand that the motion to vacate, for which recognition has been sought, is the vacating of the position internally, which I've just described?
We've already made a journal entry discussing the motion to vacate,
We stand by it.
and we stand by it.
And are we all clear in this body of what the request for recognition is to vacate a position, an internal position, a position that was elected by the members of the body itself, as opposed to a position that to which a person was elected by the citizens of this state? Are we all on the?
That's not a proper parliamentary inquiry.
Is there any misunderstanding, Mr. Speaker, as to what is being asked of you, sir, with respect to the motion to vacate?
We
Not-
don't have a misunderstanding
Sir?
I don't have a misunderstanding.
about anything at all.
Very good. Thank you, sir.
Mr. Speaker, I'd like to ask that all the comments between yourself, Representative Strom, and Representative Leibowitz be reduced in writing and placed in the journal.
Members, you've heard the motion. Is there objection? Chairperson Sloan.
Mr. Speaker,
Mr. Hartner, for what purpose?
parliamentary inquiry.
State your inquiry, Mr.
Mr. Speaker, I have a statement from the precedents of the House of Representatives, and on certain occasions, this House may turn to those precedents. Is that correct?
Our rules are silent.
That's correct, when our rules are silent.
On page 919, section 1426, in the precedents of the House of Representatives, there's a statement by the Speaker of the House of Representatives in declining to recognize a motion and in declining to entertain an appeal of his ruling. He stated there is really no power in the House itself to appeal from a recognition of the chair. The right of recognition is just as absolute in the chair as the judgment of the Supreme Court of the United States is absolute as to the interpretation of the law. Does that appear to comport with the Speaker's ruling in this situation?
It does, and is consistent with our rules as well.
Thank you, Mr. Speaker.
The chair recognizes Representative Stromer. You're recognized to make a speech on a matter of personal and privilege and not recognized for any other purpose.
All members take their seats.
Will all members again take your seats? All members take your seats.
Thank you, Mr. Speaker, and I am aware that we have an important calendar to attend to today, so I will keep this brief. But I want to tell you, I haven't slept in 2 nights, and it is not over the question of whether we should vacate the chair. I haven't slept in 2 nights because we have established a new rule that says that the power of recognition is absolute, not just with regard to the recognition of speakers for the purpose of debate, but to the recognition of motions for the purposes of actions by this House. And that, I believe, turns this entire rule book into something that is purely recyclable, because the only way to enforce the rules is through a motion by a member of this House, by calling a point of order. It is the only way any of these rules can be enforced. And if recognition of that motion is at the discretion of the chair, if the power of recognition is absolute, as it has been said over and over for the last 2 days under Rule 5, Section 24, then all of Rule 6, governing the order of business, is meaningless. Representative Hartnett cited congressional precedent. Let me read to you from the piece of paper he cited. For a long time, the speakers have exercised the right to decline to recognize for a motion to suspend the rules, but they do not have any such rights as to motions privileged under the rules and in order. During my colloquy with the Speaker, they referenced congressional precedent under Rule 1, Section 9. Rule 1, Section 9 in the explanatory notes says, while circumscribed by the rules and practice of the House, the exercise of the power of recognition is not subject to a point of order. And under appeals, it says the right of appeal cannot be taken away from the House. Members, I agree that the power of recognition is absolute in Rule 5, Section 24, when it is viewed in the context of Rules 22 and 23, because that is Chapter C of Rule 5, governing speaking and debate. And that is where the Speaker gains the power to create an orderly format for debate. If you read Mr. Hartnett's precedent, it refers to the historical background for that power of recognition to govern who gets to speak in what order because you cannot anticipate and establish rules governing who gets to speak when. But all the other rules of this House, and I'm not a lawyer, I'm a technical guy, I'm a technology person. So I went online last night and did a search of all the times in this rule book when it says the chair shall. And when it says the chair shall, the chair is compelled to do what the rule book says. But the only compulsion, the only mechanism to enforce those rules is if the chair is forced to recognize privileged motions and points of order. I've read the Speaker's journal entry about why a motion to vacate is out of order, and I have read Article 15, Section 7 of the Constitution, and I, not being a lawyer, believe a court can adjudicate the question that the Speaker argues. I don't care anymore. What I care about is that this House have rules, because if it has no rules, then the power of the Speaker is plenary, not just with regard to recognition, but with regard to everything. The calendar, the order of business, who gets to lay out a bill, what arguments are entertained on this floor, ultimately what votes we take and what policies we made are determined by one person elected at the beginning of the session and to whom we would have turned over all of our power. This system of government is one built on checks and balances. We would not, we could not, we should not cede our power to one person and give them plenary, tyrannical authority over our ability to make decisions. And a plain reading of the rules and a plain reading of precedent says that it cannot possibly be the case that the power of recognition for purposes of speaking and debate in Rule 5, Chapter C, extends to the power to deny members privileged motions, to deny their ability to make points of order, to deny 25 members of this House the ability to second a motion for the previous question. Our rules mean nothing if the power of recognition extends beyond speaking and debate. I'm not a lawyer, but I've heard the phrase Humpty Dumptyism when people talk about rulings that don't comport with the plain language of the law. So I looked up that section of Through the Looking Glass, because like all of you, I'm sure, I've felt like we've been through the looking glass for the last couple of days. And in the section where Alice confronts Humpty Dumpty, he says, when I use a word, it means just what I choose it to mean, nothing more nor less. Alice says, the question is whether you can make words mean so many different things. And Humpty Dumpty says, the question is, who is master? That's all. That's not the question. In America, that's not the question. That's not the way we do things. And so I hope the Speaker will reconsider his position on that. It is a position without precedent. It is a position that undermines the fundamental principles of government in this country. And I hope all of you will join me in encouraging him to reconsider that position. Thank you.
Members.